In 2023, a private citizen published a book. In it, he named specific government officials he believed had abused their power. In 2025, that same person became the director of the FBI. In 2026, under oath, he was asked a direct question. How many of the people named in that book have since faced some form of adverse federal action under his tenure? The answer given by his questioner, using cross-referenced personnel data, roughly 1 in 3. Today, we're checking that claim, along with 2 related threads, internal polygraph practices and a specific question about whether agents were asked how they voted, all from the actual hearing transcripts. Quick context, timeline, fast version. 2023. Kash Patel, then a private citizen and former House Intelligence Committee staffer, publishes a book titled Government Gangsters, which names a list of individuals he criticizes, reportedly around 60 names in total. February 2025. Patel is confirmed and sworn in as FBI director. Throughout 2025 into 2026, multiple senior officials, including some named publicly as part of broader reporting connected to the book, face federal scrutiny, including confirmed public investigations into figures like former FBI Director James Comey and former CIA Director John Brennan, both of whom are named in reporting as included in Patel's earlier book. 2026, in a Senate hearing, a senator directly raises the book-to-personnel action comparison. Separately, in the same and other hearings, questions are raised about internal polygraph use and alleged voting-related questions posed to agents. That's the setup. Let's get into what's actually confirmed versus alleged. The evidence. Part 1. The book, and the 20 out of 60 claim. Here's what a lot of the coverage misses, because it treats 20 out of 60 as an established fact rather than a specific calculation made by one senator's office. In the hearing, the senator states directly, "It appears to me that there have been adverse actions of various kinds taken against about 20 of the 60 people on your list." He frames this as based on cross-referencing the book's contents against actual personnel and investigative actions since Patel took office. Patel's response on the record is direct. That is an entirely inaccurate presupposition. I do not have an enemies list. He states that any FBI personnel actions are based on merit, qualification, and constitutional duty, not on the contents of a book he wrote before holding federal office. Here's the important distinction to hold on to. 2 separate claims are being made, and they deserve to be evaluated separately. Claim 1. The book exists, and it named specific individuals, including, according to testimony and public reporting, former Director Comey and former Director Brennan. That's independently verifiable. The book is a public, purchasable text. Claim 2. That a roughly 1 in 3 rate of subsequent adverse action against people in that book is evidence of intentional targeting rather than coincidence or independently justified action. That second claim is an inference built from a comparison exercise performed by one office, not a document that speaks for itself. Patel disputes the framing and the causal link, not necessarily the existence of the book or the fact that some named individuals have faced scrutiny. What is separately publicly confirmed, independent of the book comparison, is that the Justice Department did publicly acknowledge active investigations involving both Comey and Brennan during this period. That confirmation is a documented fact. Whether that fact is because of the book or would have happened regardless of it is the actual disputed question, and the hearing transcript does not resolve it either way. The evidence, Part 2. The Driscoll termination letter's legal citation. A second, more narrowly legal document thread from the same broader set of hearings. Brian Driscoll, a nearly 2-decade FBI veteran who briefly served as acting director before Patel's confirmation, is terminated. Multiple hearings reference the termination letter as citing, in Patel's own words as read into the record, Article 2 of the Constitution as the authority for the firing. A House member directly challenges this. Article 2 vests executive authority in the President of the United States. The FBI director is not the President. The member asks, on the record, under what authority Patel was invoking that specific constitutional provision to terminate a career employee. Patel's answer? That matter is under litigation, and I'm not able to discuss it. That is a legally standard non-answer regarding active litigation. It doesn't confirm the letter's exact language, and it doesn't dispute it either. But the underlying legal question raised by the member is a real citable one. Invoking presidential constitutional authority in a personnel termination letter, if accurately described in testimony, is at minimum an unusual legal basis that a reviewing court would likely scrutinize directly, independent of any political disputes surrounding the firing. The evidence, Part 3, Polygraphs and the voting question. A third separate thread, internal polygraph use and a specific allegation about voting-related questions. Kennedy asks Patel directly whether FBI personnel undergo polygraph examinations. Patel confirms yes, and importantly, confirms this has been standard practice at the FBI for decades, not something he introduced. Separately, in a different hearing, Senator Sheldon Whitehouse raises a more specific allegation that internal employee reviews, not standard background investigations, but internal reviews connected to promotion or termination decisions, reportedly asked staff whether they had voted for a specific candidate in the 2024 election. Patel's response, on the record? It's not a proper question, and it's improper to allege that I'm doing that. At the FBI specifically, under my leadership, we do not ask who you voted for. Notice the precise qualifier again, under my leadership. That phrasing denies current practice under his direct authority without necessarily addressing whether the alleged practice occurred elsewhere in the organization, at another level, or before he arrived. It's a conditional denial, not an unconditional one, and that distinction is worth sitting with rather than treating either as proof of the underlying allegation or as a full rebuttal of it. The fallout. So what's the actual fallout from these three threads together? On the book comparison, it means Patel's past public writing is now a permanent reference point that can be and has been cross-checked against his own agency's later actions in every subsequent hearing, regardless of how the causal question ultimately gets resolved. On the Driscoll letter, the Article 2 citation, if accurately described in testimony, is the kind of specific legal detail that a court reviewing the pending lawsuit will likely examine directly, independent of the broader political narrative surrounding the case. On the voting question, the conditional "under my leadership" denial means this specific allegation remains formally unresolved in the public record, neither confirmed nor definitively ruled out beyond the current period of his own direct oversight. The pivot. Okay, but look, we have to be completely objective here. The defense actually makes a valid argument on all three threads, and each deserves to be taken seriously. On the book, writing critically about specific officials before holding office is a form of protected political speech, common across many public figures who later take government positions. The existence of the book alone doesn't establish that any specific personnel decision made years later was motivated by it rather than by an independent, legitimate basis. Correlation between a list and later action isn't the same as proof of causation, and a rate of 1 in 3 without more doesn't meet a legal standard of intent on its own. On the Driscoll letter, without seeing the complete, unredacted termination letter and its full legal reasoning, it's possible the Article 2 reference was one part of a broader stated justification rather than the sole cited authority. Testimony summarizing a letter isn't necessarily the complete document, and the full context could look different from how it's been characterized in a hearing exchange. On the voting question, "under my leadership" is also simply how any executive accurately describes the scope of their own personal knowledge and authority. A new director genuinely may not have visibility into every practice that existed in the organization before or outside his direct chain of command. And a careful, scoped denial isn't automatically evasive. It can also just be precise. Real talk. How this affects actual people. The book versus personnel action question matters far beyond this one case, because it's really a question about how much scrutiny should apply when any official's past public statements can be checked against their later official conduct, a standard that, done fairly, should apply symmetrically to officials of any party, not just this one. The Article 2 question matters because federal termination letters citing the wrong constitutional authority, if that's what happened, is exactly the kind of technical defect that determines whether a wrongful termination case succeeds, a legal principle that protects any federal employee, not just senior FBI officials. And the voting question connects straight to the Hatch Act, a law that exists specifically to keep partisan political activity out of federal personnel decisions, a protection meant for every career civil servant, regardless of party. Here's what to watch for next. Continued discovery in the Driscoll lawsuit may surface the full, unredacted termination letter, which would resolve the Article 2 question directly. Expect the book comparison to keep resurfacing in future hearings as a fixed reference point either side can cite. I'll be tracking every new filing and every new hearing the same way we did today. Full transcript language, side by side, no spin. Subscribe and turn on notifications for the next breakdown. Drop below, do you think a public list written before taking office is fair game for oversight scrutiny once someone holds power over the same people? Or is that comparison unfair on its face? Let's talk about it in the comments.